The next matter to come before the court is Shawn Herhold versus Smith Land Company.
Morning, Your Honors.
Morning. All right. It looks as if the appellee has waived oral arguments, so you will have 15 minutes to argue your case as you wish. We have read the briefs and we are prepared when you are.
Good morning, Your Honors. My name is Thomas Skidmore. I represent the plaintiff and appellants in this case, the Shawn Herhold and Malavan Herhold. Herhold is here this morning to hear arguments. The defendants in this case are the Smith Land Company and Robert Smith. This case has a very storied history from a factual and a procedural aspect. Since we only have 15 minutes this morning, we're going to touch on some of the highlights of the facts in the case and why we're here. First, some of the factual highlights, which are outlined in our brief from pages 13 to 19. This is a real estate transaction. It's a vacant land sale. For the court to have a visual, it's on Brunsdorf Road in Fairlawn. If you know where the offices of Stark and Knoll are on Ridgewood Road, Brunsdorf Road is one of the side streets down in that area. It was originally developed by Smith Land Company and Robert Smith back in 2000 to 2002. There's about 12 houses that are on this particular roadway that were part of this development. As the seller in this case is the Smith Land Company. My clients are the buyers, and it's a vacant lot. And, they purchased in 2002 for $55,000. In that sale, it involved a contract, and then there was a vacant land seller's property checklist that was given to my clients prior to the time that they made an offer on this property. And one of the key disclosures, or non-disclosures, I guess, in that property checklist is the question number 4 that states, are you aware of any violation of federal or state EPA rules or regulations? And Smith checked the box, no, he was not aware of any federal or state regulations or rule violations with regards to this vacant lot. The transaction closed in September of 2002. And also the visual in this case too is this particular lot. You'll see the evidence in the case. There's a plat map that's filed that shows that this lot was split as a part of Block A. Block A was originally supposed to be a wetland area that was not to be developed in accordance with the U.S. Army Corps of Engineers application and permit. And at some point, it's our contention, it was at trial, that Smith learned or believed that he didn't have to comply with this permit because there was a change in the law through the United States Supreme Court. Of course, this is all after the fact, not at the time. He then subdivided and split this wetland area, Block A, into 3 parcels and then put them up for sale. My client purchased one of those 3 parcels and later found out, and through this litigation, found that this parcel was never really supposed to be split and sold. As a result of this...
Excuse me.
Yeah.
Never supposed to be split. Where was that established?
I'm sorry, it was supposed to be an established wetland according to the permit by the U.S. Army Corps. There was, if you look at the original plat...
So it had to, because it was a wetland, it could not be subdivided?
Well, it could be subdivided. You know, I'm not sure I know the answer to that question.
Well, if it's not relevant, we'll move on.
Okay. So what happened is that in the permitting process through the U.S. Army Corps, and you'll see the evidence in the case in the map, show that there was a portion of this particular lot that was allowed to be filled with this permit. And the contention in this case was clearly it was overfilled. You know, if you look at the particular lot, it was overfilled, and that's the contention in the case, is that he violated that permit, he put excessive fill on the property, and then he turned around and tried to sell these properties. As a matter of fact, he overfilled several other portions of Block A, and even Mr. Smith and Smith Land still own those properties, haven't been able to sell them.
Was it ever established who did in fact put the fill on the property?
Well, the Ohio EPA came in and issued a violation letter to the Herald and said that the fill was put on by Smith Land Company while it was in their possession, but because they were the owners, they were now responsible for removing that fill. I think one of the things that I found out during this case that surprised me as I went along is we're not talking about a small amount of fill. We're talking about 40 commercial dump trucks full of fill that was ultimately removed from this site as being the Ohio EPA saying that's the excessive fill that was put on it. So it wasn't just a small amount. 40 commercial dump trucks is a lot of fill. So it also was to us it was evidence that it certainly wasn't unintentional either. I mean, clearly somebody that Smith Land was responsible for knowing what their permit said, how much fill they were allowed to put on, and they are the ones who are ultimately responsible for any excess.
Well, when you say that it was intentional, what would have been the purpose to overfill land? I mean, it would cost the person who was providing the fill.
Well, the purpose is because then you can sell it.
Well, that I understand, to fill it, I mean to overfill it.
Well, what happened was he overfilled in excess of the permit into Block A, and then he subdivided these Block A into 3 lots, and then turned around and said, now I can sell these lots because people think they're buildable, and they're not. So Smith Land had filed this application for the U.S. Army Corps of Engineers to obtain this permit to put this excess fill in, and you'll notice that the evidence shows that the conversation with U.S. Army Corps is with Karen Smith, who is counsel in this case, and also the wife of the defendant, Robert Smith. And you'll see that her name is issued on this permit. She was dealing directly with the U.S. Army Corps. The testimony of Robert Smith in the case at trial indicated that even Mr. Smith would agree that he never complied. It was his belief he didn't have to comply with this permit, but he testified that he failed to comply with certain requirements of that permit. In order to make that excessive fill, he was required to purchase 2 acres of wetland mitigation at the Cleveland Museum of Natural History in Singer Bog for $16,000. That was a condition of him being able to obtain this permit to develop these properties and put in this fill. He admitted at trial he never paid that money, and he never purchased that mitigation. He also admitted at trial that he failed to ever issue or file a certificate of compliance on that permit. When you're done with your fill and you've met the obligations of your permit, you're required to file a certificate of compliance to say to the United States Army Corps of Engineers, I got my permit, I put in the fill, and I met your requirements, and you file a certificate saying you've done that. He never did that either.
Do they inspect once they receive that notice?
Well, that's an interesting thing, and it's a good question, because my belief is that the Army Corps doesn't have the staff or the ability to come out and then do a final walkthrough. That's why they expect the certificate. The Army Corps in this case never came back out to the property to investigate as to whether or not he had met the issues of this particular permit. So he filled the fill. I don't think there's an argument or a defense in this case that there's not excessive fill. Mr. Smith argued that there's a United States Supreme Court ruling that basically came out in 2001 and 2002 that stated that he didn't have to comply with this permit anymore because it was on a navigable waterway. And this is a federal issue versus a state, and so I don't know how familiar this court is with that, but in this particular case, this is determined to be an isolated wetland. This particular wetland area is not connected in any way to a navigable waterway. I believe it was in 2001, the United States Supreme Court said the U.S. Army Corps of Engineers no longer had jurisdiction on isolated waterways. That was now the jurisdiction left to the states. But we had testimony in that case that although that's what the United States Supreme Court said, in interpretation, it's not until the U.S. Army Corps comes out and actually makes the determination that it's an isolated waterway that it actually loses jurisdiction.
And that was some 2 years after the fact.
Exactly. So it's my belief that Mr. Smith and Smith Land misinterpreted the law at the time and thought they didn't have to comply with the permit, and therefore put on the excess fill and then thinks he's okay with his permit when in fact he's not. And so we had Lee Robinette come in from the U.S. Army Corps from West Virginia, who testified as to what the law is and what the requirements are. And she very clearly testified that the Army Corps would retain jurisdiction until a determination of isolated waterway was determined. And then at that point, that doesn't mean no one has jurisdiction. The Ohio EPA now has jurisdiction once that determination is made. So in 2005, after they purchased the property, Mr. Herhold was a military person. He was deployed shortly after they purchased this property, and so some of the issues don't arise for a year or two until he returns from his deployment. So they make an application for a building permit to the city of Fairlawn, and Fairlawn comes out and says, you've got fill in excess of a permit out here, you've got to address that. They contact the Ohio EPA comes out, and they then offer a letter to the Heralds in 2005 saying, Smith Land Company put excess fill on this property in violation of the U.S. Army Corps of Engineers permit. It's going to have to be addressed before you can build on this property. The Smiths, or the Heralds, then hire a company to remove the excess fill, 40 truckloads. They were required to replace some of the wetlands with certain plantings. And the problem, we know in real estate's very unique. Once the 40 truckloads are removed, it leaves a significantly deep trench now on the northern side of the property line, never there before. And therein lies the problem in trying to sell this property. Nobody wants this. Nobody wants this property because of this significant trench.
Well, I take it that in its natural condition, there was no trench, and it had vegetation and whatever at a certain level, correct?
Not actually. The photographs in the case that are submitted in evidence should be in your file. There are photographs as to the condition of the property at the time they bought it. It was just dirt. It looks like just a vacant land, just dirt level land. It looks like it's perfectly fine to build on. And it's really a misrepresentation because it's got this excess fill on it.
Is it on the east side or the west side of the road?
I believe, I'm not even sure. If you're going down to Brunsdorf Road from Ridgewood Road, it would be on the east side of the road. And it's still there. I'm sure there's a for sale sign there. Mr. Smith Land Company still owns the 2 lots next door. I don't even think they're for sale. So the case centers around then the EPA comes out, suggests that they have to remove this. They work with the EPA to meet all these compliances. They remove the excess fill. And you'll see that there's a letter from the EPA that lays it out. The wetlands on the property were filled by Smith Land Company over the allowable limits. The excess fill occurred along the northern property line, and they used the comment, the unauthorized fill has now been removed.
Counsel, you have about 2 minutes remaining.
Okay. Well, we haven't even really got to the issues in the case, but that's the factual part of the case. This case has a very storied history. It ended up in trial in May of 2014. A jury rendered a verdict in this case on behalf on the breach of contract claim for $55,000. They issued rendered a verdict for $65,000 on a fraud claim. They reconvened and found an additional $35,000 on a punitive damage claim. After that, the jury also said the attorney's fee should be awarded in this case. Of record, you'll see Judge Reinbold was assigned to hear the attorney fee issue and the prejudgment interest issues. He heard that. He issued a final order on January 22nd of 2015. And if you read his opinion, you can see Judge Reinbold knew that Smith, during out this whole process, had awarded attorney's fees and prejudgment interest because of his delay tactics during this case. He filed 2 appeals to this court on non-final appealable orders on the eve of trial. He filed electronic bankruptcy on a Sunday night before the final pre-trial when we had all of our time and exhibits ready to present to the court the next morning. And Judge Reinbold really scolded him in that final order and awarded attorney's fees and prejudgment interest. The main issue in this case, there's 2, and I'm only going to address one now since I only have a minute, but the main issue is Judge Reinbold, or Judge Parker, after, again, a storied history that Judge Callahan recuses herself because Mr. Smith filed a motion to disqualify her with the Ohio State Supreme Court. Although the Ohio Supreme Court found that The disqualification wasn't warranted. She stepped off. It went to Judge Croce. She recused herself. It went to Judge Rollins. She recused herself. And Judge Parker ends up granting a new trial to Mr. Smith based on an issue not even raised by Smith Land Company or Mr. Smith. There's 2 points to that I wanted to make. One, the court on its own initiative only has 14 days from final entry to issue a new trial based on their own initiative. In this case, the final order would have been January 22nd of 2014, meaning that he had to file by February 5th of 2015, and his opinion contains his own initiative November 4th of 2015, more than 9 months out of rule, in accordance with Rule 59D.
And I regret to say that.
I'm out of time. Thank you, Your Honor. We would ask that the case be reinstated and the verdict in this case be reinstated. Thanks so much.
Thank you for your presentation. The court will take the matter under advisement and issue an opinion which will be sent to both parties.
Thank you, Your Honor.